Hi, my name is Carl Alden. I'm the Insurance and Government Relations Director for the Michigan Association of Chiropractors. We welcome you here today. Thank you for joining us. We wanted to put together a webinar to talk about the changes in the Michigan automobile insurance laws that took place last year, because some of the big effects of those changes are going to start being seen by your offices and you when you go to renew your insurance or buy insurance starting in July of this year. Joining us today is Leslie Kohn. Leslie Kohn is a lawyer. He did his undergrad degree at University of Michigan. And even though I am a Michigan State grad, I think Leslie is a really good guy. U of M didn't ruin him. Got his law degree from Wayne State, and of course, he's a member of the Michigan Bar. Leslie has done a lot of work with our doctors, both our members and non-members, but he's done a lot of work with chiropractors in many different areas. But he really does specialize as a plaintiff lawyer in no fault, though, as we are going to talk about. No fault maybe is a misnomer nowadays. So welcome, Leslie. Thank you for joining us.
Thank you, Carl.
Let's jump right into it. Michigan, up to this point, has had automobile insurance that was a lifetime no-fault benefit system. However, with the passage of Public Act 21 and Public Act 22 of 2019, last year, we now have a system that is starting in July of this year, I will describe as a no-fault / tort system with a choice of benefit limits. What are these benefit choices, Leslie?
Okay. Before we get into the nuts and bolts, I really want to put all this into perspective. Yes, there has been some significant changes to the 1973 no-fault statute. In 1973, there was a realization that litigating or trying to get paid medical expenses from your tort or your pain and suffering case was just not workable. So in 1973, what the legislature did was they bifurcated a patient's automobile accident patient's claim. They would look to the insurance company that insured the at-fault vehicle to pay compensation for their pain and suffering, and they would look to their own insurance company to pay for medical expenses, wage loss, and other no-fault personal protection insurance benefits. That's when the legislature bifurcated the tort and suffering from the medical expense benefit claim. Now, with the passage of these amendments in May of 2019, effective June 1, 2019, there is now it's a hybrid system, tort and no fault, like what you just described. But I've been practicing personal injury law, representing automobile accident victims, and going after insurance companies since the early 80s. Very early 80s. I've seen multiple attempts by the no-fault carriers and the legislature to deprive automobile accident victims and their doctors with rights and remedies. And we've always been able to work with it and be successful. I analogize it to like a baseball game. The no-fault insurance company or the legislature hits a hot ground ball to the shortstop. Shortstop fields it and throws the batter out at first base. That's what we do. They hit a ground ball to us as shortstop. We field it and we throw the batter out at first base. We've been doing it for 40 years, me for over like 39, and we'll continue to do that. Uh, and even with these changes that may sound ominous and may sound threatening, may sound confusing, um, I would never, ever discourage a chiropractor from treating an automobile accident victim, for treating an automobile accident patient for fear of the consequences of these changes. I think we should go about our business, um, treating patients, representing patients, and simply move forward. Um, you did make reference to, in your question, what are the benefit choices? Um, I I see that question as having two parts. A, benefit choices for bodily injury liability coverage, how much you want to protect yourself in the event that you get sued, and your benefit choices for the purchases of medical expense benefits. There used to be a time, actually since 1973, when no fault was lifetime. All no fault insurance policies provided for lifetime medical benefit payments as long as the treatments were reasonable, necessary, and related to the injuries suffered in the accident. That, that's the way it's been since 1973. And it was lifetime. Now a person um, can buy various levels of medical expense benefit coverages or caps. You want me to go into each one? And
Please.
okay, all right. If the and if the person who's listening to this or watching this wants to look at the no fault statute, the uh, the amended no fault statute, you would look at section 500.3107C. Now, a person, when they meet with their insurance agent, um, if the agent wants to sell them the lowest amount of medical expense benefit coverage, they could sell the insured a $50,000 policy. That would be the maximum amount of medical expense benefits that the insurance company would ever have to pay. But in order to qualify for a $50,000 policy, the insured must sign an acknowledgement of, so that they confirm that they understand how low this coverage is and the potential consequences to them of having such a small amount of medical expense benefits. They must be on Medicaid. They must be a Medicaid patient. And not only must they be a Medicaid patient, but their spouse and all resident relatives must also be Medicaid patients. So it's limited to just those persons. Then the next level of coverage that somebody's allowed or can buy is a $250,000 medical expense benefit coverage cap. Then they could pay extra for a $500,000 cap and unlimited. Now, my understanding that even with, and there are some discounts if you buy a $50,000 policy, $250,000 policy, or $500,000 policy, but it's I don't think that there has been much analysis done. What I've seen is that there might be a 20% reduction in your premium if you buy 500,000, 35,000, or excuse me, 35% if it's 25,000. And it can actually be as much as a 45% if you buy that $50,000 Medicaid kit. So what are from the chiropractor's perspective, what does this mean? When, and you were terrific in handing out at a seminar that you put on a document entitled Auto Accident Intake Form. Do you remember when you handed that out?
Yes.
That's a dynamite document that should be in every chiropractor's office. Because the chiropractor...
I should mention that that is available on our website under Doctor Resources, which would be under, our website is chiromi.com. So thank you, Leslie.
Yeah, it's an essential document that I think every chiropractor should have and use as an intake form when they interview a new automobile accident patient. Because the patient will probably have some idea of the type of coverage if they don't have unlimited. And if there's a concern, let's say that the patient may have exhausted already, even before they go into the chiropractor's office, that 50,000 cap, or if they've gotten close to exhausting it and there's no more medical expense benefits left to pay the chiropractic charges, the chiropractor has to know that. The chiropractor can say, okay, where have you been since the accident? Where have you gotten treatment since the accident before you came to my office? And if there was a 3-day or a week stay in an emergency room, well, there's a kind of a concept of how much that would have cost. And then if you add some PM&R or whatever, or your primary care doctor, the chiropractor should be able to figure out, not to the penny, but how much of the coverage cap has already been exhausted. But even if there is an exhaustion of the $50,000 policy, the $50,000 cap, the chiropractor has to know that if the charges that he incurs exceeds that 50,000, he can look to the bodily injury liability coverage that insured the tortfeasor to be paid his medical expenses, even if once the medical expense benefit cap has been exhausted. So even if it's a small cap, as long as the patient was not at fault in causing the accident, or not more than 50% at fault in causing the accident, there's a bodily injury liability claim against the at-fault vehicle, and the chiropractor can tap into that, which is a significant right of recovery or avenue of recovery. And what the legislature gives and the legislature takes away, we see that in cases a lot. What the legislature gave in this instance was that effective July 1, 2020, the minimum amount of liability coverage in order to legally drive on Michigan roads is $250,000. So there's a pool of dollars to go after, even for medical expense benefits, even if the medical expense benefit cap has been exhausted.
Leslie, let me ask you about that bodily injury liability. Can the doctor bring the suit against the driver who's at fault, or does the patient have to do that suit?
It's my understanding that the patient does.
Okay.
But the doctor can lien the patient's third party or pain and suffering recovery. I have always, in my entire career, signed lien documents allowing, this is even before the revision, allowing the doctor to be paid out of the patient's pain and suffering. And the rationale behind that is that but for the doctor treating the patient and thereby evidencing the nature, extent, and severity of the injury, and but for the doctor, if appropriate, disabling the patient, if the injuries are sufficiently severe to disable, then there wouldn't be a third-party case. There wouldn't be a pain and suffering case. So the doctor should not be excluded from getting his payment for his treatment or her treatment out of the pain and suffering case because it was the doctor that made the third-party case. And my clients have always understood that and were willing to pay their doctors out of their pain and suffering case in full because they realized the importance of their doctor. Now, with the change in the law, the doctors actually have a statutory right to lien the pain and suffering case.
Leslie, you gave us a lien form that we have, again, up on our website under Doctor Resources. Is that still a good lien form to use?
Yeah, yes,
okay.
And if any person watching this or listening to this webinar wants to talk to me about liens, I will, I'll talk to them, of course. Now, the doctor isn't the only entity that has the right to lien the third-party case. If there is an ERISA plan, an employer-provided self-funded ERISA plan, they can lien the third-party case.
And so, Blue Cross is very aggressive in doing that.
Right, and Blue Cross Blue Shield may have a subrogation claim to get their money back. So the doctor may not be the only entity possessing that lien.
If the ramifications of somebody choosing poorly in terms of what level of insurance they want to, because basically when you decide what PIP level that you're taking, you're deciding what level are you insuring your own body plus your family members' bodies. And if somebody's looking at just what is the value of the premium I have to pay, they may decide to take out PIP coverage that in no way is going to fulfill their needs that they may have if they're in a severe accident.
I agree, but remember, you got to qualify for that $50,000 policy.
Right, but even a $250,000 policy or a
right.
$500,000 policy,
right,
in a serious injury goes quickly.
I agree. The only way to address that is for the agent to educate the client or the customer regarding these are the ramifications or consequences. Also, you're not locked in forever. Once you buy that coverage, you can change. So even if you are and we can get into this later, you can even opt out. Right, and I will explain that. But there are provisions written into the statute that does allow you to change in the event that you make a mistake. Obviously, you can't change after the fact and say, geez, I wish I would have known and bought more coverage originally. But if you buy it, and it's like buyer beware. If you bought it, you're stuck with it unless you change it, and you change it before you get hurt.
Right. Now, that brings up a question about what level of liability should somebody carry. So for our doctors who own a business, if they've been in it for any length of time, hopefully they're successful and they have a house and kids to be put through school and all the stuff that you hope to achieve it through life. That bodily injury of 250, by my way of thinking at least, is probably not adequate. I advise our doctors to consult with their insurance agent. As a business owner, an umbrella policy may be something that they want to take a look at, or they may want to do it through their insurance. When the law changed, I went out and upped my liability coverage to $1 million. Do you think that's a smart way to go?
Yes, that and an umbrella policy. You should have the maximum amount, obviously, that you can afford of bodily injury liability coverage. I have over $1 million. And I also have that umbrella policy. And you said you in your lead-in, you talked about having assets, etc. You might not be able to protect your personal assets. You can't throw your personal assets into your corporation and thereby protect your personal assets from being attacked by placing them in the business. You can't do that.
Yeah.
So it's, yes, that if you are negligent and you cause a horrendous injury, and you are inadequately insured for bodily injury liability, yes, your personal assets can be attached. And if there's an excess judgment, let's say the person goes to trial against you and they get a judgment in excess of your liability limits, that is not a debt that is dischargeable in bankruptcy.
So that's something that you'll carry with you for.
Yeah, it's a sort of Damocles hanging over your head. So it's and it's especially not dischargeable if you were drunk.
Right. In order to sue for bodily injury, the person you're suing has to be at least 50%.
Right.
Correct.
Correct. So yes, you should have a ton of liability coverage.
Leslie, a PLLC, which is a common designation with many of our members, does that give you the same protection for your business as being an actual PC would do, or is that lower level?
PC and PLLC, in my understanding, are pretty much the same. The distinction is between a professional limited liability corporation or a professional corporation and an Inc. INC. A chiropractor or a chiropractor's office cannot be an Inc.
Right.
Okay. An Inc. and that type of an incorporating designation would allow you to put your personal assets into your corporation, and thereby protect yourself if you're sued from your personal assets being incorporated or being touched. A professional, a healthcare professional, lawyer, anybody that owes a fiduciary duty to the world cannot be incorporated with an INC. Their personal assets are always subject to being attacked. A chiropractor office cannot be incorporated with INC.
Right. Very good. You had mentioned some of these opt-outs. Since maybe now would be a good time to talk about that.
According to the amendment that came into effect June 1, 2019, and this is section 500.3107 in parentheses small d, an insured can opt out of no-fault coverage altogether. The agent must inform the selling the policy in order to work with this opt-out provision. Must make sure that the insured has a qualified health plan, that there's some coverage, some health insurance coverage that qualifies in order to opt out of no fault. Qualified meaning pays for the treatment rendered to recover or rehabilitate from an automobile accident company or an auto accident injury. Now, many health insurance plans include an auto accident exclusion.
Right.
So if the health insurance plan includes an auto accident exclusion, it doesn't qualify. Medicare may or may not qualify as a qualified health insurance plan and allow a person to opt out of no fault. That's subject to, I'm sure, litigation, but certainly the person would have to have Medicare Part A and B, and their spouse and all resident relatives would also have to have Medicare Part A and B. And also, to be a qualifying health insurance plan that would allow a person, if they have it, to opt out. And this is something that the chiropractor should be tuned into. Let's say the person does have an HMO and they've opted out. And the HMO covers chiropractic. But the HMO has only certain designated chiropractors who are within that HMO. If the person is getting treatment that's covered by the HMO, chiropractic, but outside their HMO plan, then not only is there no fault because they've opted out, but there's no health maintenance organization, there's no HMO coverage because they're treating outside their plan. So if a person comes in injured in an automobile accident and the chiropractor learns that they have opted out of no fault, the chiropractor would have to do his due diligence to find out if the person has a qualified health insurance plan that the chiropractor can then bill and receive treatment from. Now, if the person has opted out, oh, and by the way, this opt-out is also coordinated to that HMO. But if the person opts out, the doctor can still look to the patient's bodily injury liability claim to be paid their medical expenses. The bodily injury liability claim, the pain and suffering claim, is for excess medical expenses, not paid by no fault, or not payable by no fault. So that's the safety net, so to speak. And again, in order to opt out, the agent selling the policy must make certain that the client then becomes the chiropractic patient has a qualified health insurance plan that pays for the treatment rendered to recover, rehabilitate from an automobile accident. Hope that explained it.
Now with that, if somebody changes, most people get their health insurance through their work. So if they change jobs so that they're no longer, or COVID hits and they're laid off, so they no longer have health care coverage, what happens then?
And then they get a new, oh, wait a minute. So at the time they purchased the policy, they had a qualified health insurance plan.
Right, but
and
during
then
the term, something happens, so they no longer have health insurance to fall back on. What happens?
They would, if they no longer have a qualified health plan and they've opted out, they have a duty to quickly get no fault coverage where they've, in a sense, opted in. But let's say they didn't.
Right.
In my opinion, because they had valid coverage when they bought the initial policy, the chiropractor can look to the bodily injury liability plan for compensation for the pain and suffering to get paid.
My understanding is they would have to, because if you don't take out PIP coverage within 30 days, you no longer can. Plus, you can't go into the assigned claim, which somebody would if I was walking down the street and got run over, and I didn't have my own insurance, I didn't own a car, I'd go into the assigned claim. Well, if you are one of these people that opted out, you can't go into the assigned claim. So then you would have to go to court and hope that the court saw the other driver as being at fault.
Correct.
Leslie, you had mentioned, there's one other opt-out, though you had some questions as to whether you thought this was going to stand up in court, it sounded like. For Medicare, there's an opt-out provision for seniors. But it sounded like you thought that might be subject to a court challenge.
Yeah, that was in the old statute also. And the reason why I think that's subject to the court challenge is because Medicare typically does not pay for automobile accident injury treatment. That's why I'm concerned whether or not Medicare may even qualify as a qualified health plan.
Medicare certainly isn't adequate. For example, if you go to a chiropractor to seek relief from an accident, Medicare is only going to pay for the adjustment, the exam, x-rays, any kind of other modalities or physical treatments that you may need would have to come out of your own pocket or sue to recover them. Because Medicare just doesn't cover more than that to a chiropractor. Physical therapy, oftentimes people that are injured in an automobile accident may need years of physical therapy. And there's definite yearly limits in the Medicare program. So I guess my point is opting out is a really bad idea.
Well, I agree, especially the only way, if you have Medicare, the concept of using Medicare as a qualified health insurance plan is problematic, in my opinion. I don't think that Medicare, I think that the courts will eventually decide that Medicare does not qualify as a qualified health insurance plan because the statute, the Medicare statute, indicates that it's not supposed to pay for automobile accident injury care. That's why Medicare could also have a lien on if Medicare does pay, even though they technically shouldn't have. They have a lien, just like ERISA and Blue Cross, against the pain and suffering case because they pay for something that they shouldn't have paid. And I deal with Medicare liens from third-party cases all the time.
Yeah.
So I know that there's language in the new statute that talks about Medicare qualifying so long as the person has both A and B, and so does their spouse and all the resident relatives. But I think that's just going to have to be litigated piecemeal and figure out what all that means. Because I really don't think that Medicare, this is just me talking, I don't think Medicare can actually qualify as a qualified health insurance to allow a person to effectively opt. You have to have an insurance that pays for automobile accident injury treatment.
And even health insurance, if it does allow for pay for an automobile accident, isn't designed to meet your needs in an automobile accident most often. People can be injured horribly when tons of metal crash together. Health insurance is really designed for relatively minor conditions and illnesses.
And
Um,
ER care.
and ER care. And with copays and deductibles, we're headed towards catastrophic care only. You know, I have a heart attack, I have cancer, those kinds of things don't bankrupt my family. Anyhow, we're kind of
But
getting.
but even if that's the case, and I agree with you 1,000%, if there's unpaid medical, you look to the pain and suffering case, and now the minimum amount of liability coverage is 250,000. So, God willing, there'll be coverage to pay for any unpaid or excess medical expenses.
Leslie, you had mentioned that our old no-fault system paid for reasonable care that resulted from the need of an automobile accident. That has stayed the same, is that correct?
Yes, but then the question is, who decides what's reasonable?
True.
Okay. Yes, the statute still, I have it in here, still pays for allowable expenses consisting of all reasonable charges incurred for reasonably necessary products, services, accommodations for an injured person's care, recovery, or rehabilitation. Now, the new statute did deal with products or services. It's not all products or services. I know that some chiropractors prescribe pillows or braces or things like that. If the no fault is of subtle changes in the law, if the new no fault law distinguishes between actual treatment and products and services, and therefore does not pay for products or services, like a TENS unit or a brace or a collar, those services or those products or those accommodations are payable through the bodily injury liability claim. Now, getting back to what I said about who decides what's reasonable, it was always up to a jury to decide whether the treatment was reasonable, necessary, and related to the car accident injuries. Reasonableness has always been a standard left up to a trier of fact, a jury. A judge cannot make a determination as to what is reasonable. What the new legislation added was this utilization provision, where a cabal of, this is my cynicism, of doctors would review records and bills submitted by the chiropractor to decide whether or not the treatment is reasonable. There's this utilization review board. It's part of the Department of Insurance and Financial Affairs. It's a panel tasked with the responsibility to determine reasonableness and necessity of treatment. The legislature did not really provide us with a criteria to determine reasonableness or necessity. But when the panel makes the decision whether or not the treatment was reasonable or necessary, that deliberation is not discoverable. You can't ask for the minutes of the meeting, or you can't depose the panel. But the bottom line is the doctors must supply treatment and billing records and an explanation as to why this treatment is reasonable and necessary, and why even it might exceed what's typical. Let's say a person comes in with something very acutely traumatic from a car accident, why that type of an injury, given that mechanism, would warrant more care, more frequent care, more care for a longer duration. And, but it, there's an issue as to whether or not the decision by the Utilization Review Committee creates a presumption of reasonableness, whether that's a rebuttable or irrebuttable presumption. All this has to be litigated because the no-fault insurance company is going to say, well, this Department of Insurance and Financial Affairs Utilization Review Board said, well, treatment after this date is no longer reasonable or necessary, so we're going to rely on that and we're not going to pay anymore. You can still sue the no-fault insurance company and say that the Utilization Review Board was wrong and you, the chiropractor, are right and more treatment is necessary. So we have to learn in future cases, judicial decisions, whether the Utilization Review Board can be relied upon, to what extent it can be, their opinions can be relied upon, whether it's a presumption, all that sort of stuff. It's just going to come down.
Chiropractor, who oftentimes is not a very expensive provider compared to, live-in health, surgeries, all those kinds of things, will often be put into a position where what is owed is not worth going to court over. You'll end up spending more money going to court than what you would ever be able to collect. So
I don't know what that threshold would be, Carl. I guess.
Well, if an outstanding amount was $3,000 and a lawyer is going to charge $5,000 for seeing this through court, you can't afford to go to court. A good
obviously
decision.
Right, but
go.
But if I don't mean to keep hitting this, but if the no-fault carrier denies based on the Utilization Review Board opinion, and the patient still has a pain and suffering case, you can get the excess from that. And I have litigated cases in the district court for relatively small sums. It's just a relationship I have to have with the chiropractor, that I will do this for the chiropractor, maybe take a loss myself, but still litigate in the district court. I do that. And I'm not going to list the doctors that I do that for, but because they didn't give me permission to do that. But yes, it can be done.
Right.
I don't think that's an insurmountable hurdle. Now, even if the no-fault carrier denies if they don't base the denial on the Utilization Review Board opinion, they can still deny based on an IME.
Let's talk about IMEs because there was big changes in that. The
Right.
old law had no guidance other than the insurance company could insist somebody go to an IME. And if the patient didn't, that could be a reason to deny. So what has changed now with IMEs?
You can't deny based on the insurance companies have in their policies provisions that there's a duty to cooperate. Yes, you cannot, as a patient, refuse to attend an insurance defense evaluation. What the new law did change was who qualifies as an IME doctor. There used to be the You just had professional IME doctors
Right.
who did nothing but spend 5 minutes with the person, never really examine the person, and then deny, write a report saying either A, there's nothing wrong with the person, or B, if there is something wrong, it's because of something that was there before the accident.
Right. They would kick out lovely reports.
Right. It's all degenerative and nothing traumatic. But a lot of these IME doctors, insurance defense medical evaluators, were just professional IME doctors. They did nothing else. Now the law says that the IME doctor must be licensed, board certified, or otherwise qualified to treat the patient's condition. And during the year before the evaluation, the doctor must have devoted most of his or her professional time to active clinical practice relevant to that specialty, or taught students at an accredited medical school, residency, or clinical research program for physicians, including instructions to students relevant to that specialty. Okay. So the not professional IME doctors will no longer be able to do that. And the credentials of the IME doctor are discoverable. I have a standard request for production of documents or interrogatories where I ask the defendant insurance company to provide me with, what this doctor has been doing for the year prior to the IME, and if his credentials qualify. But also, just like forever in the past, the IME doctor, his opinions are subject to cross-examination. I routinely cross-examine IME doctors so that I can destroy the credibility of their opinions. We focus on bias, or the duration of the examination, or what records they reviewed, and we focus on how much they got paid, and how many of these they do, and how much their yearly income is dependent on these IMEs. So our payments from these IMEs. So the IME doctor is always subject to cross-examination, and a good plaintiff's personal injury attorney can tear an IME doctor apart. But that is after the lawsuit has been filed, both the pain and suffering and the no-fault claim has been filed. So the way to deny, based on the injuries themselves, not on how qualified health plan, all that sort of stuff, but on the injuries themselves, is either with that utilization review or the IME doctor. And either way, plaintiff lawyers, if they know what they're doing, will still come on it. They'll still win, because jurors see through an IME doctor like they're made out of glass.
Yeah.
What the insurance company lawyer says is that the insurance company doesn't have to rely on the opinions of the treaters, and that they're allowed to have these IME doctors. As long as you can exclude from the jury any reference to these doctors being independent, then and instead replace the word independent with insurance, the jurors are going to understand.
Yeah.
Does that make
Leslie,
sense?
you had brought up in an example where using an HMO. Now, actually, within the auto insurance laws, there's now managed care options that the auto insurers can sell. Does the law really give much in the way of guidance on how this is going to work?
Options for what? Tell me, explain
For
this.
managed care, you can actually buy from your
Oh,
auto insurance a managed care plan.
oh, yes. The no-fault insurance company can offer a managed care option with a discounted premium. And the discounted premium has to reasonably reflect the anticipated reduction in expenses. If the patient bought managed care, and that's MCL 500.3181, 3182, 3184, it allows the no-fault carrier to monitor or adjudicate a patient's care, and allows the no-fault carrier to create a preferred provider program or a network. And if a chiropractor wants to join that network, I believe he does so at his peril, but he would have to sign an agreement willing to cap his charges and cap the number of treatment and cap the amount cap the duration, and also cap the modalities that he uses. And the chiropractor would also have to be approved by the no-fault insurance company. And there has to be a specific number of chiropractors in that network for any particular area or region. A person who buys managed care and wants to go to a chiropractor won't have to drive 100 miles to go to a chiropractor within their network. So there has to be enough chiropractors in that network so a person can have a short drive to any chiropractor. The managed care plans are primary, which means they pay first, and they cannot be coordinated with no-fault coverage. It really does throw a number of Michigan Supreme Court and appellate court decisions, flips them totally over, because there's many cases that say no fault is not managed care, or comp is managed care. No fault was always fee for service, and the no fault insurance company could not manage a person's care like a work comp carrier can. Now they are allowed to manage the care, but only if a person bought this managed care option. And there's a form that the person would have to fill out when they buy that managed care, so that they know what they're buying, and that they can leave that managed care, obviously not before a car accident injury, but they can leave it at any time after they've bought it. Personally, I don't believe that the managed care can require a person who wants chiropractic to get treatment other than chiropractic. So let's say there aren't chiropractors in the managed care plan, and the person suffered a spinal injury. This is going to be litigated, I'm certain, and I hope I'm the one that does. I don't believe that the no-fault carrier working under a managed care option can require a person to seek treatment other than what they want. Right? So if they want chiropractic, they can't make them go else to a PM&R, and if there's not enough chiropractors in that region or area, I don't think they can make them drive to a chiropractic office very far. So this is something that will be litigated and resolved. But that's effective July 11, 2019. Now, the reason why, even though it's been a year since that managed care option provision has been in effect, is because the Department of Insurance and Financial Affairs hasn't approved the document that a potential insurer has to sign to acknowledge that they're buying this managed care. Right. Same thing with the $50,000 Medicaid cap. The agents don't have that document to give to the people. So I don't, and to show that they signed saying, I understand what I'm doing to myself. That document hasn't reached the insurance agencies.
I suspect it will within the next 2 weeks.
You?
I
Okay,
do.
well,
They've
you
had
have,
public hearings on it already. They came out with a draft and had public hearings, and I expect that they will, before July 1st, have those out.
yeah, I know that there's been a lot of arguing about it. But I guess the language will be essential. I don't know, cynically speaking, if an insurance agent who makes his living on commission from premiums, if they want to sell these really, really cheap policies with really low premiums where they get nothing in their pocket.
Well, the No Fault Act also doesn't protect them from, failure to do due diligence claims against the insurance agents. It's something that through CPAN, I know many insurance agents are rather worried about and very concerned about.
Say that you lost me.
There's if they sell a policy that inadequately covers somebody, and that person then is in an accident that exceeds what they bought,
Right.
worried about being sued by their clientele who bought the policy, that they didn't do due diligence in terms of explaining options, and he didn't warn me of these effects, and
There's
pulled into their liability.
There is a theory of errors and omissions. Insurance agents, errors and omissions claims, and errors and omissions coverage. And there's how you can sue an insurance agent for not adequately advising. There's a distinction between an insurance agent who's captive to an insurance company. Like, let's say you walk into an Allstate office and buy a policy versus an independent agent who's not captive to any particular agent, any particular company. But most of those lawsuits against insurance agents, even if they're not captive to an insurance company, still fail because there's an issue of whether they are a fiduciary. They have a fiduciary duty to the client, and if they ask all the right questions and the person fills out all the right boxes, I think they're protected. I remember a case where an insurance agent was selling a policy to an individual, just kept renewing the policy over and over and over and over again, year after year after year, decade after decade,
Right.
And with the same coverage. And then the insurance agent goofed and failed to include uninsured motorist coverage. And the person got hurt by an uninsured motorist, and they didn't have uninsured motorist coverage. And they sued their agent for not including the uninsured. That case failed. So I think the law protects these agents. But it's certainly worth going after. Who knows? Maybe with these new changes, there is an added responsibility on the part of agents to do more, to cross off more boxes, to do more due diligence, to make sure that the person does have, let's say, a qualified health insurance plan.
That sounds like something that will be for the courts to decide.
And that's another thing for the courts to decide. That should be the takeaway from our webinar today. So much of what we've discussed may or may not ever happen, and if it does, it will be immediately challenged, and it'll be up to a court to decide. I'm not talking about the whole law itself, the whole amendment, because I think challenging the whole law on its constitutional basis as violating due process or equal protection, I don't know if attacking the entire amendment will be successful. I hope it is, because I know that there's some efforts out there to do that. But I think that the challenges will be to individual provisions, like what you mentioned to me before, that provision that all spinal injury facilities have to be certified by this certifying agency.
Yeah,
I mean, that is certainly going to be litigated.
and that's typical of any law. This law was was written, and really nobody saw it before they voted on it. Leadership came out and said, here it is, vote yes. It passed through, got signed into law without anybody really knowing what was in it. And laws that are passed that way invariably are going to have unintended consequences, are going to have clauses that may be in conflict with each other, just because not enough eyes looked at it and went, hey, what about this?
Also, because it was passed so hastily, as you just described, it was very poorly worded.
Yes.
A lot of it makes no sense.
Right.
So then the court has to step in and figure out what the legislative intent was in drafting this provision. It will be subject to multiple
Well,
litigations on all the different provisions that I've been describing.
well, Leslie, that guarantees that we'll be doing many of these webinars over the next few years.
Yeah, I know one for certain that we're going to have to do, and that's when the fee schedules start, in anticipation of the fee schedule kicking in, and that's July of 2021.
Correct. We have another year before that smacks us in the face.
Right, but I'll educate the chiropractic community on the fee schedules and how that applies as that July 2021 deadline kicks in.
Used to be under the old law, that an insurance company that didn't pay a claim timely, which the law gave them 30 days to pay a claim once they had all the information they needed to adjudicate a claim, which by my way of thinking is the CMS 1500 form. It's got all the information they need. Of course, the insurance companies love to ask for records and send people IMEs and all that kind of thing. But there was some interest penalties if they didn't meet the timely payment. Has that changed at all under this new law?
Yeah. If the doctor does not provide what constitutes reasonable proof of the claim, and in my opinion, it's not just the CMS 1500 form, it's the treatment notes and the billing records. If they don't provide that reasonable proof within 90 days of the date of treatment, then the no-fault insurance company has an additional 60 days from the original 30 days to review, and if they don't pay within that additional 60 days or 90 days, then the treatment or the payment is presumed to be unreasonably delayed or denied, and then the doctor, once payment is accomplished, either by way of litigation or the insurance company does finally get around to paying, they're entitled to interest, which is 1% for each date, for the 1% of what was owed on that date. It's not compounded interest, it's just statutory.
1% simple interest.
Right,
Which
simple interest
equals 12% per year.
per year, but it's 1% on per treatment.
Right.
So what the new law did was it extended the ability to pay by an additional 90 or by additional 30 days, additional 60 days, if the doctor doesn't submit reasonable proof within 90 days. But you know what? That's workable. I mean, if it's reasonable to require a doctor submit a claim within 2 days.
And most doctors are quite used to doing that.
Yeah, I don't, I think this was designed to discourage chiropractors from holding on to bills for a very long time and then submitting a massive bill to the no-fault insurance company. And then if they don't get paid within the old law, within 30 days, then it's interest on that massive bill when they sue. That was a policy that I think that became kind of archaic, but chiropractors did do that at one time.
Yeah, when I came in back in 95, that was kind of a common belief. This is the way to get paid. Do the whole course of treatment, then bill. But the problem with that seemed to be, one, insurance companies thought that was an indication of fraud. So they'd really look at things. And secondly, you run into the 1-year statute of limitation, which in the new bill can be told while you're getting records together and sending them into the insurance company. But
and the
still,
insurance company's investigating.
Yes. But there's still those dates you have to be careful on.
You still have to file suit within 1 year of the unpaid medical expense to get paid. If the insurance company was paying, and then they denied, the 1 year back rule is told, and from not the date of the first unpaid treatment, but from the date of the formal denial. What that does is that it prevents the insurance company from stringing along a chiropractor where they don't formally deny and they just claim we're investigating. And then there's finally a formal denial, but it's been more than a year since the date of treatment. Then the insurance company says, ha, you didn't file suit within 1 year. And now you can't even ask for that payment. Now you have a year from the date of the formal denial.
Which is, I don't believe there's much improvement in this law, but that is an area of improvement.
Yes, I agree. It's now that the no-fault insurance company can't string the chiropractor along, say, yeah, you're going to get paid. We just want this document. We lost this one. Please send us this one again. And then the chiropractor waits more than a year from that date of treatment to sue. And the insurance company says, well, you waited too long to sue. Now you can't ask for it. Those days are gone.
Yeah. And they had become very good at doing exactly that. Leslie, I want to thank you for participating in this and lending your knowledge and expertise and experience to our doctors. As we go through there, I would imagine not only from the courts, as you've mentioned, but I know there's efforts in the legislature to change some of the provisions of the new law. For example, we mentioned that the fee schedule is going to take effect July of 2021, there's entities out there, especially the places like Special Tree and Eisenhower Center, and those kinds of very intensive patient in facility for closed head injuries, for spinal cord injuries, that probably would be put out of business by the fee schedules. There's going to be a concerted effort, I know, over the next year to try to change those fee schedules. So I think you're right. We'll have to talk about what is going on as we get closer to that. But I want to thank you for today's efforts.
Carl?
Yes.
I don't mean to interrupt. I'm sorry. There's one subject that I wanted to make sure that the viewing, listening chiropractors understand. They may ask themselves and ask you or me the question, well, what services, or did the new changes affect what services the no-fault insurance company is still responsible to pay for? First of all, the new law does not address that. So in my opinion, under the new law, the no-fault insurance company still has to pay for any treatment that was within the scope prior to its expansion. They have to pay for adjustments 98940, 98941, 98942. They have to pay for traction 97012. And they have to pay for myofascial release 97140. Maybe electrical stimulation 97014. So all these modalities are still payable as a no-fault benefit. I don't want the chiropractor to think they have to now not treat the way they know how to treat.
Right. Yeah, I think always, it doesn't matter whether it's an auto patient or some other type of insurance patient or a patient that's paying out of pocket. Do what's necessary for the patient.
I agree.
And it seems to be those doctors that do that have extremely successful practices. But I'm happy to mention, most of our doctors know that if it was not part of the definition of chiropractic prior to January 1st, 2009, the auto insurers may pay for a service, but you can't compel them to pay for a service. So it comes to the choice. So we see things like massage that actually the insurers have a court case saying they don't have to pay that to chiropractors. Well, House Bill 4449, by the time we have this up on ready for our members to view, I believe will have passed through the Senate. We'll be back to the House for concurrence, and it's on its way to the governor's desk. And that will say that basically the insurance companies have to pay chiropractors for their full scope, as long, of course, as it's reasonable and necessary due to injuries from an auto accident. So that will actually be a bit of good news coming down the pike.
Thank you, Karen.
Leslie, thank you again. Anybody that's listening to this, if you find yourself that you need a lawyer that really knows what they're doing in auto insurance, especially if you're a member of the MAC, I would urge you to give Leslie a call. Actually, Leslie's a good guy if you need advice from a lawyer in almost any field. He is very, very good at dealing with our members. He understands the chiropractic office, the chiropractic profession. Many lawyers do not. And you can spend a lot of money bringing them up to speed. You don't have to do that with Leslie. Also, Leslie, we have found to be extremely good if you are asking him to represent you or advise you in an area that is not his area of expertise. If he doesn't think he's the one that can do the best job for you, he'll let you know, which is a wonderful thing in a professional. I think in any profession, it's a very ethical very, I'm lost for words, the right thing to do. And Leslie does the right thing. He's concerned for who he represents and their patients. We're proud to be associated with him.
Thank you very much.
And with that, we want to say thank you very much for watching this. We hope that it's helpful. Of course, if it leads to more questions or you run into a situation where there's more questions and you're a member of the MAC, why wouldn't you want to be? Give us a call, the MAC. And if it is beyond something that we understand, we certainly will be probably suggesting that you give a lawyer a call. And Leslie is the first one I'd recommend you call.
By the way, just as an aside, if you're a MAC member, you're allowed to call my office and get a free 1/2 hour consult. I don't bill for the first half hour. That's free. It's a member benefit for you paying your MAC dues.
It is a really valuable benefit. We ask, though, that you don't abuse it. Leslie could be overwhelmed.
I'm fine. Don't worry about it.
But that is a very valuable to be able to say, talk to somebody and find out, yes, you do need a lawyer. You do, I think, have a case. You can move forward if you choose to, or no, you don't have a case, or you need a different kind of lawyer or a different kind of professional. This is really something that a CPA maybe is going to help you with better. To get that kind of advice and get pointed in the right direction is very, very valuable. And it's something that the MAC, like I say, we're proud to be associated with Leslie, and we're happy that we can have those kind of benefits. So thank you very much. With that, be looking for information as more information becomes known, coming out to you. Thank you.
Thank you very much, Ken.